Good morning. Again, I'm Tiffany Reedy from the Harris County Attorney's Office. Our current county attorney is Mr. Vince Ryan. I'm one of the executive managing attorneys. My focus group is child welfare and adult protective services. You are present in the immigration law CLE that's being hosted November 8th here at Texas Southern University's Thurgood Marshall School of Law. We're going to allow Professor Cologne's student ambassador to introduce the law school and also the master's program in immigration that is hosted by this school.
Hello, my name is Michaela Kirkland. I'm the president for the Institute for International and Immigration Law here on behalf of Professor Fernando Cologné. We at Thurgood Marshall School of Law provide a master's LLM program in immigration and naturalization for continuing students to gain more experience in immigration studies. We also have an institute here for that provides a certificate program where if you obtain 15 credits in academia pertaining to immigration or international law, you graduate with the distinction in immigration and international law. Thank you.
Thank you very much. Thank you. Most people in the room, I hope you know, Harris County is the most populous county in Texas. At about 4,652,980 people as of 2017, we're actually the third most populous county in the entire country. And since 2010, the fastest growing of the 10 most populous counties in the country. Harris County is one of 48 Texas counties with more than 10% undocumented residents. And it has the largest raw number of undocumented people, estimated to be 764,767, or the approximate size of a congressional district. While 16.9% of the county is undocumented, 26% is foreign-born. As the Harris County Attorney, Vince Ryan has always strived to provide service to all according to the law, and our immigrant communities deserve to be treated with dignity and due process of law in relation to detainer proceedings in the immigration process. Because of that, his office, by and through myself and my team, is working, we're working with organizations in the community such as the Houston Bar Association, the American Bar Association's Children Immigration Law Academy, Kids in Need of Defense, and the YMCA, just to name a few, to make an effort to educate attorneys interested in representing children, human traffic victims, and adults in this immigration detention process. I just told somebody this morning that the issue that burns in my belly is a human issue. We see these things on the news and we wonder, how can we be impactful in this work? Being able to take a case, represent a child who's in front of a federal judge with no one else present is probably the best thing that any lawyer can do if they have the time and the resource. And there are organizations that you will be exposed to today that actually do that work. And we want you to be able to do the work and be educated in a way that is helpful to those organizations. And that's why our county attorney has allowed us to put on this CLE. This CLE is actually going to be the first of a 3-part series. The second immigration law CLE, similar to this one, will be focused on people who are trafficked, either in the sex industry or in the work industry. And the third will be adults. So after this training, as you can tell, it's being recorded. It's going to be uploaded to a website for future CLE credit for other people or other lawyers to experience and to learn from. And then we will plan the other 2, and you'll be notified of those as well. Okay. Prior to me continuing, I'd like to introduce one of the judges from the 14th Court of Appeals. And Judge Jerry Zimmer is here, and we'd like to give him an opportunity to speak to you guys this morning.
Thank you, Tiffany. I am Jerry Zimmer. I am a justice on the 14th Court of Appeals. I have 10 county jurisdiction, including Austin, Brazoria, Chambers, Colorado, Fort Bend, Harris, Galveston, Grimes, Waller, and Washington. The Court of Appeals, obviously, is the intermediary court, and it is the court that reviews state law issues as they come before the court, first in a trial, but then to the appellate level. Oh.
I'm sorry, Judge, to interrupt you. I apologize.
Quite all right. Thank you. So the reason I'm here is to let you know that the judiciary is concerned about these issues as well. The judiciary is concerned. I think the legislature is concerned. And we can look at the history of the law as it relates to children, Texas law as it relates to children. We protect children. We create special classes of children. We don't allow them to marry. We don't allow them to sign contracts. And so, once again, I believe that the legislature and the Texas law protects children. And so in this case, I want to let you know that we, the judiciary, are concerned. I'm going to share with you that Chief Justice Nathan Heck, who may be my opponent in November of next year, is also going to be giving a presentation today by videotape. And I join him today in encouraging the continued work and the continued effort to try to protect children in Texas. Thank you.
So in order to introduce Chief Justice Heck's video presentation, I'd like to introduce to you Mr. Terry O'Rourke from the Harris County Attorney's Office.
Thank you. My name is Terry O'Rourke, and I have the joy of working for Harris County Attorney Vince Ryan. And if Vince were right here right now, I know exactly what he would say to you, to all the people here. Thank you for being here. And even more, especially for the people who aren't here, are going to see this on videotape, how important this is that you do what you're doing. And I can tell you that 4 years ago, we had a conference very similar to this. And there were lawyers who showed up, and some from our office. And just because you're an assistant county attorney didn't mean that you couldn't volunteer to be a lawyer. And one of them, a lady that a lot of you know, Julie Countess in our office, took court appointments, took assignments, and represented children who had nobody else other than she. And she did a wonderful job. And of course, Julie Countess is a member of the First Court of Appeals of the state of Texas. And she sits just in the very same building that Jerry Zimmer does. He sits on the 14th and she sits on the 1st. So whether you wear a black robe or a badge or you are a lawyer, this is really, really important. So volunteering is everything. So we did this 4 years ago, and Justice Heck was gracious enough to say what many people would think is dangerous territory for the judiciary, to really call out members of the judiciary to say, don't think about politics. This is not about Democrats or Republicans or Libertarians or anything else. This is about children who don't have lawyers. And so as you see Hecht, who is in many respects the leader of the judiciary, listen to the call, because if Vince were standing right here, he would say, get the lawyer friends that you know, not just you, but your lawyer friends, to do this. This is, if there is any belief that you have in a higher power or a deity or whatever, and you say this, that this is the work of God on this earth, if you're a lawyer, is to do this. So, are we ready to roll? Chief Justice Heck, thank you.
I am Nathan Heck, Chief Justice of the Supreme Court of Texas. Many years ago, when I was a district judge, I would tell every jury as trial began that they were privileged to serve not just as part of the finest justice system on earth, but as part of the finest justice system in the history of the earth. I wanted them to appreciate their role in that system, to know that jury service, though a burden on their personal lives, was not only their civic duty, but a great honor. They would witness firsthand why Thomas Jefferson said, "The most sacred of the duties of government is to do equal and impartial justice to all its citizens." But the American justice system was built by lawyers for lawyers. And for the hapless soul who would or must represent himself or herself in court pro se, justice may be inaccessible, making the system seem a farce. That's why in criminal cases, the United States Constitution requires the government to provide every defendant a lawyer. The same requirement does not apply in most civil cases, even though the stakes can be very high. So the Texas Supreme Court works very hard to obtain public funding for legal aid and to encourage lawyers to represent the poor for free, pro bono publico. That Latin phrase is important, for the public good. The client benefits, of course, so does the lawyer from having the personal satisfaction of giving back. And the profession is ennobled by its tradition of service. But the principal benefit is the public good, that the promise of justice has been made a reality, safeguarding the integrity of the rule of law. Immigrants have a right to counsel in immigration court, but not at government expense. As daunting as self-representation must seem in any case, in eviction cases or debt collection cases or cases involving the custody and welfare of children, that mountain is never higher than for a person from another country, speaking another language, with no understanding of American courts or our legal system. And when the immigrants without legal assistance are unaccompanied children, the problem is dire. Self-represented parties strain courts, opposing counsel, and the justice system itself, and justice may be denied. Immigration continues to be a hot-button issue over which the country is deeply and passionately divided. It is not for courts to take sides in the dramatic political, social, and humanitarian aspects of the crisis. Our job is to guarantee that the laws will be applied equally, fairly, and efficiently to all alike. The system works best when everyone has a lawyer. Every year, Texas lawyers give millions of hours in free time, worth hundreds of millions of dollars, to provide civil legal services to Texas' most vulnerable people. Every year, legal aid providers help more than 130,000 families. The beneficiaries are our veterans, the elderly, children, and many others. Still, 3 in 4 who need help can't get it. For lawyers, pro bono representation is not charity or a government program. It's professionalism. It's being a lawyer. This course is designed to help provide you as lawyers the skills and expertise you need to represent children and other immigrants in immigration courts, as well as victims of human trafficking. I am grateful to you for your willingness to commit your time and energy to these clients, and to Harris County Attorney Vince Ryan and his office for gathering excellent materials and arranging for expert presenters to provide you the education and training you need to handle these cases. As Chief Justice, I am proud to lead a bar that is so dedicated to professionalism. I hope that your involvement in immigration cases will inspire you throughout your careers to continue to represent those who so desperately need your help. Pro bono publico, for the public good. May your efforts go far in upholding the integrity of the rule of law and ensuring, in the closing words of the Pledge of Allegiance, justice for all. Godspeed.
We really appreciate Justice Hecht and his efforts to create the video. Justice Hecht actually did a video in 2014 when we did the first unaccompanied minor CLE. And so we're really grateful that he was able to extend his efforts to us again. As a bit of housekeeping, we always like to say thank you to the people who help us, right? So it wasn't just the county attorney's office who pulled this all together. Dahlia from the American Bar Association has done lots of work with us. She's worked with our team from our office, Jacqueline Terrell, as well as Janice Dawes, as well as several other lawyers in our office. We've put in countless hours to make this happen, right? And as a result of doing the work, we find new issues to fight against and new issues to want to teach all about and to bring to everybody's knowledge, and so that we can combat these things in the future. We'd like to say thank you to Benny Agosto and the Houston Bar Association. We'd like to say thank you to Charles Foster, to the YMCA, to Catholic Charities, to the Tahirih Center, and also to Kind. In terms of housekeeping, if you notice, there is no paper, right? There's no paper except the paper that you printed off. So for those of you who did not download the presentation materials before this morning, you can find them on the Harris County Attorney's website. So if you do a Google search and go to the Harris County Attorney's office, it'll pull up our webpage for you. Then a quick and easy way to find it is you would go down to the bottom of the webpage. There's a search box. If you type in immigration, it will pull up all of the documents, video presentation, and there's Dahlia sitting right there. Wave to the people. Dahlia has been really awesome in this whole. She and Elizabeth Sanchez have been really great to us in helping us pull together the necessary people. So I just want to give her kudos in the room. Thank you. So back to how you get the documents. Scroll down to the box, type in immigration, and if you want to download the actual forms that our presenters have given to us for your benefit, the passcode is UC 2019. That's the letter U, the letter C, 2019. Let's see. In relation to today's presentation, we have provided continental breakfast. You can actually have the breakfast here in the room. So until the breakfast is gone, please eat it up. We want it to be gone. And we also are providing lunch. Our lunchtime may be a working lunch because we have a speaker at lunch. On our breaks, those Flores videos that I was showing this morning, you'll continue to see those as well. Okay, and so I'm going to step back. Another thing you'll see is we're really big on integrating our interns and young people who desire to be lawyers. And maybe they're not young people, but they're young to the law. They're still studying, right? And so we're allowing them to introduce our speakers so that they get to know more people and so that they feel more comfortable than I do in front of a mic. And given these types of speeches, and so that you all may in turn get to know them in the future as well. So Jack's going to come up next. So I took my boss's place this morning, not knowing he was going to make it. And so I'm going to turn the mic over before we let Jack introduce our first speakers to the County Attorney, Mr. Vince Ryan.
I apologize for being late as I take my youngest son to his high school. So it was a little bit bad weather today, as we all know. But anyway, just welcome you all to this very important seminar. We think, as you've already heard, that with the numbers we have in Harris County especially, these issues are particularly important. And especially with the different issues as they're being faced at the national, state level, we at the local level need to be very, very involved. So I appreciate each of you taking interest in this. Thank you for being here, and hopefully today's going to be a very informative series of seminar. Thank you very much.
Good morning. Our first speakers today will be Ann Chandler and Gerard Lynch. Ann Chandler has served as Executive Director of the Tahirih Justice Center's Houston office since it opened its doors in 2009. The Tahirih Justice Center is a national nonprofit organization that protects courageous immigrant women and children who refuse to be victims of violence. Ann was a clinical professor for the University of Houston Law Center, where she served as the interim director of the Immigration Law Clinic. Prior to joining the University of Houston Law Center in 2003, she was the director of Immigration Legal Services for the YMCA International Services of Greater Houston. A strong believer in the legal profession's ability to implement innovative approaches to eradicate human trafficking in Texas, and teaches human trafficking law and policy as an adjunct professor at the University of Houston Law Center. Gerard Lynch is a native Houstonian and citizen of Texas. He works as a staff attorney at Kids in Need of Defense, or KIND, a national nonprofit dedicated to the goal of ensuring that no child appears in immigration court without high-quality legal representation. Prior to joining KIND in 2015, he worked as a staff attorney with the Cabrini Center for Legal Assistance of Catholic Charities of the Archdiocese of Galveston, Houston, where he provided representation to detained and released unaccompanied children. He is a graduate of the University of Texas School of Law. Please join me in welcoming our first speakers.
Thank you, Jack. Thank you, everyone. Thank you, Vince Ryan. Thank you, Texas Southern University. And I want to start with, it's an honor to be here. I have never been asked to talk about immigration changes affecting unaccompanied children from 2014 today in 30 minutes. But so I can say first the main theme is going to be like everything that we were unable to say in 30 minutes. The second is like Jerry and I are buddies now because we've been on the phone trying to figure out how do we strategically get this done. So when we don't say things or miss things, doesn't mean it didn't happen. We just decided to be kind of choosy.
Yeah, and it also doesn't mean that it's not important.
Yeah.
So with that, wanted to start?
Yeah, let's start. So is somebody helping with the slides? Or do you want me to? Okay. So, to kind of set the framework, why have there been so many changes regarding unaccompanied children? And I think one of the senses that, awesome, is trying to set the background of how many children are coming, what is their situation, what are their numbers. And second, we've been living now in the United States under a general policy towards new entrants and towards border enforcement under this idea of zero tolerance. And that's had a significant impact of how we're treating unaccompanied children. So I want to talk about that. Then I'm going to pass it over to Jerry, who's going to talk about some changes in the law that are really going to impact you when you say, yes, I'll take not one immigration case, but I'll take two of these children's cases, and you find yourself before an immigration judge. And so let me just start. So I think there's a huge dialogue and framing, is there a crisis at the border, or is it a manufactured crisis? Is it something that we're creating really through our rhetoric and through our policies, things like family separation, things like prolonged use of CBP and real cruel conditions that we see towards new entrants, both children and adults? Or is there a real problem here where large number of unaccompanied children are rolling over and immigrants are coming to our country and basically ignoring this idea that we have real borders and it's a responsibility of our government to enforce those? So this is a large dialogue, and I see different folks using different statistics, all that are legitimate, and it really is one of how do you frame the issue. On the one hand, if you look at U.S. Border Patrol or Customs Border Protection statistics from the 60s and the 80s to today, you might leave with like, there isn't a crisis at the border. We don't have millions and millions of people rolling over. This is not an unprecedented number of people. But if you start looking a little bit more nuanced and look at like what is the population coming into the United States, it really has it is very different. It is dramatically shifted, and the type of responsibilities that we have in our law that put real strenuous burdens on U.S. government personnel, whether that's immigration judges, asylum officers, Customs and Border Protection, folks who take care of children in detention. It's a very different game in the last 5 years. So if you look back in 2013, 89% of the individuals arriving at our border who are apprehended without a visa were single adults, with just 9% unaccompanied children, and a few individuals in something we identified as family units, meaning children, but with at least one parent. And look how those numbers have shifted. We're unaccompanied children in 2014, when we met together as a group, that increased from 9% to 14%, significant increase, and it continues to be a significant number of individuals arriving. But look what's happened with family units, with adults arriving with children. And that's a big part of this story of unaccompanied children. So part of the changes of zero tolerance has been things like the Remain in Mexico policy, otherwise known as MPP, or Migration Policy Protocol, with this idea that you just can't come to the United States anymore and ask for asylum and remain in the United States for 1, 2, 3, 4 years until your case is heard. No, no, no. If you are a family unit, our new policy is that we screen you and we allow only a certain number of individuals, which is not very transparent of who gets the exception. But unless you are really from Mexico and terrified of Mexico or have some other very unusual circumstance, you as a family unit will be sent back to Mexico. So why am I talking about this when we're talking about unaccompanied children? Because we're seeing a significant number of cases where when those family units are sent back to Mexico, sometimes they're so desperate, and often while a family, because I work a lot with families, while a family is coming over, a lot of times they're coming over because of the situation and the terror posed and targeted to their child. Recruitment in gangs, sexual violence in girls, and we'll talk more about that. So what we'll see in some of these family units that get sent back is they'll send that child who's in the most precarious situation, and being in Mexico is not safe, alone. So now we have a new kind of group of unaccompanied children coming over into the United States. Second, zero tolerance, you can, it was that, it's zero tolerance, and it had many wrinkles, but one idea was no longer are we going to allow these family units to be released. So what did they decide? Is they decided that there wasn't enough bed space for these families, and there was a previous I'm all over the place here, guys, but there was a rule in place from a California court called the Flores Settlement Agreement, which traditionally only included class members of unaccompanied children, specifying that, how that unaccompanied children really can't be put in pecuniary, like, horrible conditions, that this was a set of regulations and a standard of treatment for unaccompanied children. So for the most part, unless they were on a federal piece of land owned by the federal government, these children had to be kept in facilities that met state licensing requirement. So what this meant is that families who were with their children for a long time could be put in pretty harsh conditions, but the Flores settlement was challenged, and that protection of what detention should look like for children was extended from unaccompanied children to children who were here with their parents. So in response to that, the federal government recognized, oh my goodness, like how do we detain these parents and these children if the children have to be put, even if they're with their parents, in a setting where there's sufficient mental health provisions, education, and all these guidelines. So they thought, well, what we should do is we should separate the children, right? And so they did this under the idea that that the law for a significant amount of time has permitted individuals who are arriving to the United States with a visa to be prosecuted, not for illegal entry, but also for not for illegal re-entry, but also for first-time entrance or illegal entry. So they said, we have to take the children away because we're now prosecuting people who are asking for asylum who are illegal entrants. So under that demise, they began to separate children in much higher numbers than we had seen before. Under this zero tolerance and this necessity of protecting immigrants who are being harmed on that migrant trail, and that we must, in a humanitarian way, ensure that we are not acting as a magnet to the United States. And so we need to use the laws that Congress passed to prosecute asylum seekers and take the children away. The cries from Americans were so loud that Trump kind of actually moved against that and said he's going to slow down on family separation. So also under this, so the zero tolerance when it came to family separation has been modified and is a much more gentle creature right now. However, Remain in Mexico is still in place for families, but it is not in place for unaccompanied children. So when unaccompanied children arrive, they are not subject to MPP. They are allowed to come in. Another aspect of zero tolerance, what I haven't talked about yet, is the asylum ban. There's been a couple of wrinkles of kind of what this is. The first was an effort that if you didn't arrive at a port of entry and arrived kind of, somewhere along the river and you snuck over the river or out with a guide, that you were not going to be eligible for asylum. That was knocked down by the courts as completely contradictory to the actual letter of the law. Another wrinkle was this idea that if you travel through another country and fail to ask for asylum, so for example, if you're from Guatemala and you come through Mexico and fail to ask for asylum in Mexico and come to the United States, you are then statutorily, we're saying, ineligible for asylum. You may be eligible for something called withholding of removal or Convention Against Torture, but not asylum. And so, like all these other measures, there was a play out in our courts in the Ninth Circuit, and it was held that went too far and contradicted actually the refugee definition and statute as we know it, as well as our international law. And that case was challenged, and there was first a stay put on banning asylum for anybody who didn't ask for asylum in one of the countries they passed through. And that stay was lifted for every circuit except for the Ninth Circuit. So if you're in the Ninth Circuit or California, unaccompanied children can still apply for asylum if they're from El Salvador, Honduras, or Guatemala, even if they didn't ask for asylum in Mexico. But for us who are working with unaccompanied children who didn't apply for asylum in Mexico, that asylum ban is still in place until it's overturned.
Hey,
turning it,
skip this.
I'm going to skip this. This is just we'll skip over to you. Sure, done.
In addition to what Ann talked about these policies, these deterrent policies at the border, things that are designed to discourage people from coming to the United States. There are also policies that they're pursuing to make it much harder for people who do make it into the United States or people, to win their case or to get release. And part of the changes one of the big changes that came to mind thinking about this was the Attorney General's actions towards case law. So in our immigration system, the Attorney General, the head of the Department of Justice, who is a political appointee, has the ability to certify decisions to himself. And what he's certifying are decisions from the Board of Immigration Appeals, which is the ostensibly neutral body of judges, appellate in the immigration system. And what the Attorney General can do is he can say, well, he can vacate decisions, he can overrule decisions, and in a surprise to probably no one in the audience, the Attorney Generals under this administration have used this ability at a very, very rapid pace. They've certified and decided more decisions than the Clinton administration, then the Bush administration, then the Obama administration. And what we've seen is that a lot of these decisions are designed to make it harder, and do, in fact, make it harder for people to get permanent relief. But of the many, many decisions, which we're not going to talk about at all because no time, the ones that I thought were kind of important were the ones that I put up there. AB and LEA are both decisions that are very impactful in terms of how likely someone is to pass what's known as a credible fear interview at the border, and actually get to even go in front of a judge, as well as ultimately in their final hearing on the merits of their claim. And if you look at the dates on that, the AB decision, that's the holding there is a matter of ARCG, which was a case involving a Guatemalan woman who was horrifically abused by her partner, who couldn't get any help from the authorities, any protection from the authorities, and who ultimately won her case. And in that ARCG published decision, the court held that Guatemalan women who cannot leave their relationships could be a particular social group, or was a particular social group. And it was a monumental decision because in our asylum system, we've had so few precedential decisions that have come out our way in the last 20 years. Well, maybe none, actually, come to think about it. I mean, Anne, what do you think? Since Kasinga, has there been anything from the Board of Immigration Appeals that has gone our way?
No, that was a big one. And the impact of this type of case on unaccompanied children was quite significant. So to have matter of ARCG, the one positive case that recognized, that intimate partner and harm to the child when things are violent, and that state has failed to protect individuals, to see that decimated and removed was heartbreaking.
Yeah, so the Attorney General quickly said that case was wrong. It's overruled, using his power. And then in the matter of LEA, and this is, even though the decision in which it was partially overruling is not as old as the matter of ARCG decision, I think it had a very a long pedigree. And what that decision was talking about was whether or not it was a family asylum case, whether someone could, how to analyze nexus specifically, like to analyze one element of the asylum definition as it pertained to family-based asylum claims. So someone saying, I'm going to be harmed because I have this unchangeable characteristic that I'm a member of my family, everyone knows it, and I am being targeted and going to be killed because of it. And the Attorney General, interesting fact about LEA lost. They found that there was no nexus, so they failed to meet this necessary connection element that's in asylum cases, which I think we'll probably talk about a little bit more on a different panel. But what was good about LEA is it said family membership is a particular social group, so it gave some guidance. And what the Attorney General did is overruled the part that was beneficial to us, and also added some additional language in there that was intended to make it just a little bit harder to win cases. And then I picked the matter of MS decision, and I think the MS decision is important because what it tells us about what the future might be, and the possibilities. but MS was overruling a 2005 decision. It was overruling a very well settled case at this point. And what that case was whether or not someone who passed a CFI, a credible fear interview at the border, could be released on bond. And the Attorney General overruled that, but, and this is the important part about it, is that it's currently enjoined. And I think that tells us that it's important to keep litigating these cases, because even though the Attorney General does have this power, it can change. And we've seen that. This is not some hypothetical. In the Compine decision, which has nothing to do with this administration and is not from 2014 onward, that was a Attorney General decision decided at the very tail end, the waning days of an administration, 13 days before the president left office. And then 6 months later, a different president vacated the decision, right? Yeah, vacated. So while we are having all these monumental changes on the case law side, in addition to all these changes that Ann talked about and on the border affecting people who are coming, this is something that is, it's not necessarily going to be like this forever, and it's important that people fight their claims and fight them well, so that they have a chance to fully explore their options, right, and potentially get a chance to stay here. So in addition to all these changes in case law, there's also been a lot of changes in case processing in the immigration courts, which is EOIR, as well as the Department of Homeland Security, the immigration agency. And they're absolutely too numerous to name. There's so many. You'd have to have a very wide-ranging practice to have been affected and be fully informed about all of the different policy changes. But one thing that's important here in Houston is with EOR is we have a lot of new judges. We have a lot of new immigration judges. And less important in Houston, but important nationally, we also have a lot of judges retiring. Judges are retiring at the fastest pace that they ever have in our immigration court system. And as we know as attorneys, it's important to know your judge. And with that sort of instability, it's become all the more important to meet with other attorneys, to learn from our the experiences we have, to share these experiences. And the other thing that's important in court is the fact that some of these case law decisions, that they are affecting how what will happen in court, whether or not we will be given sufficient time to pursue humanitarian relief. Not going to go into detail about those, but and then there's also just a lot of pressure on judges. Under this administration, they've adopted case completion guidelines, which kind of impinge on the ability of judges to be neutral in deciding cases. And while from what I understand, it's not tied into how much money they make at the end of the day, but it is tied into sort of the perks that they might be given. And if they do not meet these targeted goals, which right now is 700 cases closed per year, which was higher than the average amount of cases that a judge was completing at the time it was enacted, that they will be deemed unsatisfactory in performance. And maybe that means they don't get to transfer to the city that they'd like to transfer if their family needs to transfer. Maybe it means that they're assigned more to the detention centers where the courts where they would prefer not to go to in the city that they are. In addition to that, I mean, there's been a lot of since 2014. There's been a lot of docket reshuffling. The judges do not have that, like in addition to all these things that impinge on their ability to decide how they're going to decide, we've had, at the very beginning of the surge, we had cases where we were set for final hearing, and we were ready. For instance, I had a case where it was 2 weeks before the final hearing, for which we had been waiting for 3 years. We get a notification saying it's been rescheduled, and we're in a check-in court date, like a pre-hearing court date almost type thing, in 2 years in the future. And a lot of other attorneys got that at the very same time for the very same date. It was just, this docket reshuffling just to focus on, in that case, recent arrivals over people who had been here for many, many years. And in some cases, that's been good for people who are not necessarily going to get the results that they want in their case, but it's also been bad for a lot of people who have high likelihood of success and did not get a chance to present their claim.
So I'm told we're supposed to wrap up. I mean, what we wanted you to kind of take away from this is the one thing that is not changed since the last few years is that everything changes all the time. And so, like, while today there is no asylum for unaccompanied children, there really is likely to be asylum sometime, I think. This is all being challenged in the federal courts. The judges are completely strapped. There's great unpredictability what may happen in the courts, but that too is very fluid. And so the wonderful thing about all this change and lack of predictability is that the organizations present here today and CELA of the American Bar Association is going to be able to walk you through all the current changes. And when the current changes is really what we know about that particular judge or that particular string of cases that's happened in the last few weeks, because it's a fascinating area of really dynamic law where the federal courts and the agencies are trying things that are really unprecedented.
The thing I wanted to add also, just to plug, is I think with all these changes, it's more important than ever that kids have representation, and that we as attorneys, we work together to be better representatives. For as hard as it is to keep track of all these changes, as someone who's in the field, it's all the more impossible for someone who's pro se to do that, especially a child. If you do get a chance to take a pro bono case,
or two,
or three, or work and support other pro bonos, please consider it.
All right, so that wraps it up, and thanks for being here, and we'll pass it back to Jack.
Okay.
Oh, excellent. We have a few minutes. How about some questions? Yes. Right.
So you were mentioning that the Flores requirements made it difficult for families and children to be detained together in order to sort of meet those requirements. Does that mean that they are meeting those requirements where children are detained alone, generally?
Good question. So, the Flores settlement it was traditionally unaccompanied children, and it was expanded to include the family units. And then the federal government, after that expansion, they decided what we need to do is we need to take over and control, meaning Health and Human Services, Department of Homeland Security, need to redefine what detention looks like for children, both accompanied and unaccompanied. So they drafted their own after asking for comment, they drafted regulations so that they would be out of that, what they view as a chokehold from the federal court in mandating what the conditions of detention look like. So they issued regulations, and I think it was August 21st, 2019. And really by August 26, 2019, the court had said, no way, we're still regulating detention and what those conditions look like. Did I answer your question?
I guess what I was after is I've heard presentations from inspectors of these detained
Yes.
areas that seem to indicate that even with the Flores requirements, we're not meeting them.
We're
The
not meeting
children
them.
who are
Yeah.
detained really are experiencing some pretty harsh conditions that violate Flores.
Absolutely. So, one way you may want to volunteer, and we'll talk about this at a later session, is being involved with the inspectors and the modeling of going into detention and literally seeing what it looks like in children and whether all these principles and regulations put down by the Flores Settlement Agreement are being complied with. And we have lots of documentation that is really problematic. And given how many detained children we have in Houston, it's something we really need to recognize that is a problem. And this kind of has two folds. It has, number one, the law around the detention of children says that within 72 hours of a child arriving on U.S. territory, that jurisdiction of who holds the responsibility for that child must shift from the Department of Homeland Security to Health and Human Services. So another trend that we have seen, unfortunately, with the current administration is a complete flagrant violation of this responsibility of getting children timely out of DHS care over to Health and Human Services. So we have, there are also inspections happening not just in Health and Human Services and the Office of Refugee Resettlement facilities in our region, but also inspections in the Customs and Border Protection buildings. I don't know what to call them. I call them baby, cages. They're horrible. They're frozen places where children and adults are intentionally treated like animals. Their clothes are taken away. It's freezing. They're given frozen food. Our government doesn't believe that in those situations children should have access to soap or to toothpaste. There's been a lot of deaths in these centers. So yes, there is Flores monitoring opportunities for attorneys, both looking at those CBP facilities, which need to end immediately, and some of the problems that exist within the Health and Human Services facilities, which, at least in our region, really try and say that they abide by state licensing requirements and try to treat children. I don't know if there's anything you want to say there. Yes, other question?
Is there a coordinated effort to hold the government responsible? And what are the consequences to the government if they don't meet the requirements?
Oh, we got to recruit you. Is there a coordinated effort to bring accountability to the system?
I think Man was already talking about the Flores monitoring. People are trying. I'm not involved in that, so I don't have anything to add. Yeah.
There is. I think they're happening on several levels, right? I think one level that's happening is just raising the consciousness of the American public so that we are able to hold the government account, because there is a lot written on paper of what accountability looks like. And though when you get in and get under the rules, that's not what's happening, right? And so there's also a lot of effort to do kind of impact litigation and coordination across the United States of when there are these regulations and new ways of doing business that violate our international accords on the humanitarian treatment of unaccompanied children. How is this being it is absolutely absurd that an unaccompanied child, given how dangerous that journey is, and the type of trauma that they have suffered, that they should be aware that they have 30 days of which in their Mexican journey to apply for asylum in Mexico. This is absurd, right? And so we need to kind of change that culture and awareness and use the courts effectively, and there's a lot of efforts going on.
Yeah.
Question, how many unaccompanied children do we have in Houston today? We do have that number, and I'm looking over to somebody who next session is going to get you that number.
Do you want to give us a preview?
No.
All right, we'll have to wait.
We have 1 more minute for one last question.
Yes.
No. Not even close. Less than half.
Less than half.
Yes. Is there an age range for an undocumented child to apply for asylum, or how do they get that done?
Great question. I think we have another session about that, but
There is?
we didn't provide the definition of an unaccompanied child, and I think that's where we should have started.
The definition of unaccompanied child goes to age 18.
Great question. So unaccompanied children, most of unaccompanied children that we're working with do not have, are apprehended. Many turn themselves in at the border. Those children are then find themselves into detention centers that are run from by Health and Human Services, and organizations that are present with us today, such as Kids in Need of Defense, such as Catholic Charities, and now YMCA International Services, have attorneys and efforts to go out and educate those children and help those children apply for asylum. Most children are released from these unaccompanied detention centers across the nation. So children, we have many who are detained, and we have many who are living in and going to schools with our kids. And in both populations, but specifically those that are released, many do not have immigration attorneys. But these kids are still in immigration court proceedings, trying to explain and about their legal case, with the dream of remaining in the United States.
And the chief way in which kids are identified is through that shelter system. There are attorneys that are funded under subcontract. Can you repeat?
So, did you say they get a guardian? Oh, yes. So I appreciate that. So we're going to have some other conversations the way it's worked is when children are released from federal detention, you would think that the state and our court may put in place some type of guardianship or managing conservatorship, some type of legal document that would allow that family sponsor or that person who took in that child, say, to have some type of, let's say that child did not go to the home of a parent who was living here, but went to an uncle. That is not something that's just organically going to happen in our system. That only happens through the efforts of the organizations that are here today, who will be asking you, if you take a case, to evaluate if going to those state courts and getting that type of guardianship-like instrument is something that you would be willing to do. Because it's critically important for reasons of healthcare, being able to get that, and also for immigration purposes.
Thank you, Ann.
Yes.
Everyone, please join me in thanking Ann and Gerard.